now invite Stephen, if you have any comments on because we're in the started the discussion regarding the dispute section, and as counsel, maybe there's a comment that you would like to add.
Can I run for a little bit? I want to comment on what Galina said, but let me start by saying, as Galina said, we covered all this twice already, and so we're going to be a little bit more ad hoc in how we do this, but the idea is to build on the discussion that's been happening all day so far. And I guess from my perspective, let's take a step back. We're at Sarajevo Arbitration Day, so we want to talk about arbitration and sustainability. And what do we mean by sustainability? What we really mean is climate change, environmental issues, sustainability. We mean human rights. So let's talk quickly about how do we get human rights into arbitration? Where does it come in? Because traditionally, when we talk about climate change, environmental issues, it's happening at a state-to-state level through the ICJ and mechanisms like that. It's happening through states prosecuting or regulating locally. So where does it come into arbitration? Because there's a possibility of an arbitration mechanism in various climate change and environmental treaties, but those have never been taken up. And again, that's state-state. And what we really want to talk about is how do states defend themselves? That's what we were talking about when we're talking about investment treaties. But we also want to, I think, talk about how do states actively bring claims against polluters or people who breach sustainability goals, and what are the mechanisms for doing that? And does arbitration play a role in that? And why do we care? Because states have the prosecutorial and regulatory power within their four corners, but if a polluter is sitting in a different jurisdiction and has very little in the way of assets within the state has a toothless remedy if it's prosecuting or regulating locally. So I want to quickly just think a little bit about where we're moving, both to talk about the reform efforts within investment arbitration, and you've heard a lot about that this morning. Let me just highlight a few things on that. One is we have two streams of reform. We have substantive reform and we have procedural reform, and the efforts so far have focused more on procedural reform. And so we see ICSID failing to do anything substantive, tweaking procedures. We see the working group 3 trial stuff really focused on an investment court, on advisory center, things that are, again, not the substance of rights, not the substance of obligations. And I don't think that's the place, frankly, where that discussion should be happening. So where does it need to happen within the treaty space? It needs to happen within treaties, within either discussions of how we're going to frame new treaties or reform other treaties. And despite the mess we've seen now with the ECT and all the complexities, and we can go in circles for what was happening there and what might still happen there, there were certain things that I think are important and when we think about reforming treaty rights, and that is there was this notion of tweaking in a thoughtful way the definition of an investor, and particularly a protected investment. And that's, again, how generally across different treaties we can start to address some of these issues. What is a protected investment, and are certain types of industries not protected? There was no effort, and I still haven't heard anyone define fossil fuels. So that's an important thing, but to define what the investment is. Then you had the notion of clarifying the substantive standards. What is fair and equitable treatment? What does it cover and what doesn't it cover? And that's a space where there's a lot of room to create clarity that would help both investors and states if there was more predictability about what is protected and what's not protected. The ECT reform was also trying to deal with what indirect expropriation meant. Then we build in the flexibility mechanism that we've talked about this morning, as well as this review mechanism where every 5 years you would review the state of the world and consider whether the treaty needed to be modified. So that's the sort of approach that needs to be done, but I think it needs to be done even more effectively through ECT has got so many issues, but we see other places in the world where that effort is going on, and a place that doesn't get enough attention for this is Africa, where there has been really thoughtful efforts to attack these issues. The Pan-African Investment Code and the Africa Continental Free Trade Agreement both have very thoughtful approaches on not only defining goals that aren't just aspirational and aren't just state-state like the new, there was a reference earlier to the Dutch New Model BIT, and you were sort of, Galina was sort of coming back to that, this idea of the states to a treaty having some recognition of obligations that are environmental or human rights related. There are in the African, both the PAIC and the African Free Trade Agreement Investment Protocol, there are efforts to make more practical goals and put obligations on investors, and we see that now in some of the new model bits coming out of African countries. So if you really are interested in this, look at the Morocco model bit, which not only requires economic contribution like many bits do, but it has performance requirements related to sustainability. That's where we can start to create these obligations. It's not just collaboration, but it's also performance obligations. And I think that's the direction we should be looking when we're talking about reform. Because I don't want to take too much time, I want to quickly mention something that no one's talked about, I don't think, and I apologize if someone said it this morning, but it's counterclaims. Right? Most treaties, there's a very big question about whether or not you can bring counterclaims. It depends on the language of the treaty. We are now seeing at least a few examples in treaties where there is scope to bring counterclaims, successful to a degree, counterclaims by states for failure by the investor to do environmental remediation. So the most well-known cases are a couple cases against Ecuador, where in the Parenco case, for example, while Parenco won something like $350 million in damages for Ecuador's interference with its project, the tribunal also found it was knocked down from 90 million because of double counting to about 50 million in favor of Ecuador on a counterclaim, which then was obviously set off against the amount owed to Parenco. So that's, if we want to give states more opportunity to bring affirmative claims and the option to choose, do I want to do this through an investment treaty, where at a minimum it's a defense or a set-off, but also potentially allows me to enforce internationally as well. Maybe we need to be thinking about, it's a procedural reform, but a reform that says states can bring counterclaims. And just to bring it all together and let other people talk. The previous panel was talking about performance requirements, which is why I kind of direct your attention to the Morocco bit. But that's also how we can bring climate change, sustainability, human rights into commercial agreements. And I think it was mentioned in the previous panel that you could put this into investment contracts. But the more that states can put, or state-owned entities put performance obligations into commercial contracts, you then have a place where we might see arbitration of some of these issues, and you have a two-way street. It's not a one-way path where the state is subject to claims and may have defenses. It's a chance for states to have affirmative opportunities to go after the people who may be at fault for some of the issues we care about with climate change. And so that idea of putting in performance obligations, and actually there are investors who don't mind this. You know, there are lots of investors who, for both cynical and genuine reasons, don't mind having those obligations put into commercial and investment contracts. So that's another place where we bring arbitration in. And then let me just, when we talk about human rights, I think sometimes this is widely known and sometimes it's not. There's also the model from the Bangladesh Accord. And I think that's something worth thinking about. And if you don't know the Bangladesh Accord, this was after fires in the garment industry in Bangladesh and lots of deaths in factories. There was an agreement reached among the garment industry companies who use factories in Bangladesh to create a code of conduct. And then there's a whole process which leads to, if there's a challenge to a company's behavior under the code of conduct, it goes to a panel, advisory panel, but then there's a right to arbitration that comes out of that. And that's the sort of mechanism that with cooperation you can bring arbitration again into solving some of the sustainability or human rights issues that we're talking about in a way that's a two-way street and not just a one-way street.
Thank you, Stephen. And I would just add, when you mentioned that there's investors who don't mind these standards, I would just add it's not only that there are investors who don't mind, there's also investors who count on it, who mustn't be forgotten. We're also a topic of their own discussion.
And when I say cynical reasons, because sometimes their investors, you know, they're public companies and their investors insist that they agree to abide by ESG requirements. And so there is opportunity there. And you know, we should be cynical about all this, but we should think about how to use that cynicism constructively.